Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of von Valkenburgh versus Lutz. This case was heard in the New York Court of Appeals, year of 1952. Let's go ahead and jump into the facts of the case. So the Van Valkenburghs bought a piece of property in Yonkers, a suburb of New York. This property had a vacant lot behind it. This vacant lot was owned by the city, but the city hadn't done anything with it. It was just kind of undeveloped land. The Lutzes, wanted more property, so they began to just kind of use this vacant lot as their own. Mr. Lutz built his younger brother, who's a little bit mentally handicapped, a home on the property. Mr. Lutz began to farm on the property. He had Mr. Lutz's farm, which everyone from the neighborhood came and shopped at, and he raised chickens on the property. So it was, quite a large piece of ground that he had just kind of made his own, even though it was completely abandoned and not his in completely the legal sense. So in come the von Valkenburghs. They moved to Yonkers, and they really didn't like the Lutzes very much. So they went to the city and they bought the deed to this piece of property. They bought the title and said, hey, this land where you guys are on now is no longer yours. It's actually ours. So you need to get all your stuff off. So there was a bunch of legal battles that ensued, obviously, because of that. And ultimately, there's this case that we're going to discuss here, which came to be because there were some negotiations prior where the von Valkenburghs said, hey, you can't have your stuff on the property, but you can walk across it. And then ultimately, Lutz tried to walk across it, and eventually the Van Valkenburghs built a fence over his path. So they just both got frustrated, and this ended in court multiple times. But ultimately, what we're discussing in this case is adverse possession, and whether or not the Lutzes had, through adverse possession, a property interest in this vacant lot. So adverse possession is a doctrine in property law which states that if someone inhabits vacant, which is seemingly vacant property for a period of time, it can be theirs. In New York statute, that period of time was 15 years. The Lutzes had been living and farming this ground for much more than 15 years when this suit was brought. So this is a decision that's up to the court. Do the Lutzes have a property right in this lot, even though they didn't actually purchase it through adverse possession, or do the Van Valkenburghs have the property interest in this lot because they actually purchased the lot from the city of Yonkers? So ultimately, the court rules in favor of von Valkenburghs and says that because they purchased the land from the city, that they actually had the property claim to it, and the Lutzes had no adverse possession. They said that because the Lutzes didn't in a sufficient manner cultivate and improve the land, that the Lutz didn't have a property interest in accord with adverse possession. This was a split decision, and there's a lengthy dissent written on it as well, which does argue that the Lutz should have a property interest in this because they cultivated it, they farmed this lot, they built structures on this lot, they had acquired this through adverse possession. Ultimately, the city never told the Lutzes, like, hey, this is our ground, you guys need to get off of it. And that's a key component of a property acquisition through adverse possession. But ultimately, the majority was in favor of the von Valkenburghs, and the Lutzes didn't win the case and didn't have property rights via adverse possession. It's worth noting that the dissent does have a lot of weight behind it, and ultimately the court ruled in favor of someone similar to the Lutzes and said that this adverse possession did occur and it's their property. A lot of legal scholars actually put more weight into the dissent's opinion on this case than into the majority's opinion. So that's why I mention it in the brief. So that's the case. As a ruling, deals with adverse possession of property. Ultimately, there's some other just scenarios that I want to discuss about adverse possession in the era of the internet, because it's not quite as likely that we're going to see adverse possession of vacant lots quite as often. I mean, most often when we see adverse possession is like encroachment on boundaries now, not like full lots. It might be more prevalent in countrysides, but if you're in a developed area, you're not going to see this very often. So let's think about how adverse possession might apply to Bitcoin. When Bitcoin was young, people would purchase thousands of Bitcoins for pennies, and they would put them, in wallets all around the globe. And there's been studies that say, there's tons of Bitcoin out there in abandoned wallets. Well, if I were to create a company, or you were to create a company where you went around the internet and you surfed the web and you found all the Bitcoins that no one had used for years. If you cultivated those, thereby increasing the interest in them by bringing them out of the dark caves of the internet where the prior owners had no idea where they existed, do you now have a property right through adverse possession to all those Bitcoins? Interesting question to think about. An ex-ante scenario that's a little bit more concrete where this law might apply. Envision you have a broken down car, you go to a car mechanic and you say, hey, fix this car. Let's just say the car is only worth $1,500. The car mechanic says, hey, to fix it, it's going to cost you $3,000. You decide, hey, I don't want to put $3,000 into a car that is only worth $1,500. It's not going to increase the value that much to make it worth it. So I'm just going to leave the car on the mechanic's property. Ultimately, the mechanic doesn't say much to you. He's not like, hey, you need to come get this car, but he just lets the car sit on his property and ultimately starts repairing it, fixes it up. He does it for much less than $3,000 because he doesn't have to pay for labor. And ultimately, he then goes ahead and sells the car. Maybe he sells it for $5,000. Do you still have a property interest in that car? Probably not. I think that the mechanic has acquired title to your vehicle through adverse possession in an instance like that. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more videos, go ahead and hit the subscribe button. I hope you have a nice rest of your day. Bye.